by your king, Clifford Jefferson, the city of Godfrey, fifth kind of Grand Jew, son of fourth rule of Jerusalem. You are now in Jerusalem with the spiritual chieftains of Jerusalem, which means the city of peace. I have amongst me is two of my vanguards, Archbishop Belmont from the House of Belmont, and Court Judah from the House of Murphy. We're here setting the record straight in regards to making sure that you're registering as a citizen of the English National. If you're not registered as the English National, then you're subject to the poll tax that has been subject to of all citizens here in what we call North America, known as feudal tenure. We're here today come to clarify and clear up how our state got usurped by aliens known as the House of Stuart, the House of Handover, the House of Saxon-Coburg, the House of Windsor, and all those other houses that existed prior to that, such as the House of Tudors. We know that a lot of legislative acts were passed by de facto legislation, by de facto monarchs under de facto parliaments, i.e. rump parliaments, bad or good. That goes back to the time era what we call the 100-Year War, where the census term actually originated from under what we call John Gaunt. I'm on the class. Go back over there. It's cold, boo. Yeah, so as we know, the origin from the concrete overstanding comes from John Gaunt, son of Edward III, under Edwardian war that descended with the conflict between Carnatic and that succession. The Alien Act, as we just showed you from Parliament of England, which is our forefathers, i.e. the House of Lords, which are our peers, established an Alien Act that permits or forbids Scottish kings, Scottish ancestors, Scottish descendants from making claims on any of the estate of English heir successors in lieu of the Alien Act of 1705 as a result of the Security Act of 1704, which preceded by the Settlement Act of 1701. And that was a result of the act that were permitted by that same de facto in lieu of the Plantation and Settlement Act of 1740. And these were dealing with the Protestants who were inhabited the American colonies, now known as the United States. Okay, let's just go to that real briefly. Security Act, where is that? Here we go. Plantation Act of 1740. All right, now we said that our ancestors in 1705 passed the Alien Act that forbids Scottish monarchs, Scottish heirs, Scottish descendants, Scottish corporations that were established by charters, which are nothing more than transmission of power and rights granted by a monarch, whether de jure or de facto. As we can see, it's de facto as a result of what the Alien Act stated in lieu of those acts passed by the de facto parliament under the House of Stuarts, such as the Security Act of 1704 and the Act of Settlement of 1701, which resulted in the Treaty of Union of 1707 under the de facto Kingdom of Great Britain, now known as the United Kingdom. The Plantation Act of 1740 is an act in reference to the United States Constitution, July 2nd, 1776, which makes mention of the so-called colonies when they declared their independence from Great Britain, which was under the monarchism of King George III. So this act within itself states the very verbiage which Archbishop is about to read to you. Plantation Act of 1740. Go ahead, Archbishop.
All right. The Plantation Act of 1740, or the Naturalization Act of 1740, are common names used for the Act of British Parliament that was officially titled an Act for Naturalizing such foreign Protestants and others therein mentioned as are settled or shall settle in any of His Majesty's colonies in America. The act became effective on June 1st, 1740, and allowed any Protestant alien residing in any of their American colonies for 7 years without being absent from that colony for more than 2 months to be deemed His Majesty's natural-born subjects of this kingdom. The act also required making specific declarations concerning royal allegiance and succession, profession of the Christian faith, and in payment of 2 shillings, compared to
tax.
Tax. Tax, yep. Compared to other alternatives available at the time. The act provided a cheap and easy method of imperial naturalization, and the length of residency was not unreasonable.
Okay, so as you can see, naturalized or born, if you're subject to the laws of that which was established by the charters given by the king, de facto king, under the House of Stewards, under the House of Handovers, under the House of Saxe-Coburg, as well as the House of Handovers, that estate was not yours. It was based off the Charitable Use Act of 1601. All right, which goes back to Elizabeth I first. All right, so it says that the act also required making specific declarations concerning royal allegiance, which determines your political status as a subject protected by the king. All right, but as you can see with the act established in 1740, was a plantation act, as we read in the July 2nd, 1776 Constitution, as well as the Virginia Constitution of June 29, 1776, as well as the Virginia Charter. They spoke about colonies, not states. So if you're a state, you're in a world of trouble. Why? Because those states were actually colonies, referring to those plantations and settlements that were created by grants given by de facto monarchs in reference to those communities who were based off religiously based societies, which were nothing more than charitable use-based groups as trustees set up to yield for us at the early successors based off the original charter that they did not adhere to. All right? So the Plantation Act of 1740, as we stated in the Elliott Act of 1705, clearly pointed out that any colonies that were allowed to come here under the Protestant religion were subjects of the monarchs of what we call the Kingdom of Great Britain of the Treaty of Union in 1707, which was under the de facto monarch under the House of Stewards, known as King James, Charles I, Charles II, William II, and William III and Mary II, Queen Anne, and everybody else who succeeded them.
Father.
All right, this is a problem because that does not follow the criteria in regards to citizenship. All right, how we know that? Let's go here. Read, Archbishop.
All right. The Nantis Ultra Mare, also known as Status of Children Born Abroad Act 1350, was an English statute during the reign of Edward III. It regulated rights of those born overseas and was an early precursor of British nationality law and others. Dating from 1351 during the early part of the 100 Years' War, it addressed the issue of inheritance by foreign-born children, a topical problem.
Read that Hornberg chapter again. Remember, we started off talking about census. And the origin census started off in the 100-Year War between our house and the House of Belmont, which were Roman Catholics. All right? And those Roman Catholics, Spain and France, succeeded all the way back to Great Britain, who were of the Roman Catholic Church, but under the misnomer as Protestants. So they knew what they were doing.
Yeah.
All right. Now we're reading about the Natius Ultris Mare, which is Status of Children Born Abroad Act of 1750 in regards to establishing the limits on British nationality law. All right. Read the next paragraph.
This statute of Edward III was invoked over 200 years later in two matters. In the first of those, it did not prove effective since the outcome went in the other direction. But in the second, it was significant. In the debate on the succession to Elizabeth I, it was thought by some to be telling against claimants of the House of Stuart.
Read that part again.
In the debate on the succession to Elizabeth I, it was thought by some to be telling against claimants of the House of Stuart. In Calvin's case, it was also brought up to argue against the proposed right of inheritance in England of the Scottish post-nati, those born under the Union of Crowns of 1603.
Okay, so it was said to be telling on against the succession claimants of the House of Stewards. You know what I'm saying? So somebody's been lying. Somebody's been lying to you about who the true heirs and successors are. Why? Because this act clearly said that it told on what the House of Stuart offered the auspices of Elizabeth I, who was the daughter of Henry VIII, who reformed the English Church of England, which was a violation of the Religion Act of 1705. All right? And it said that it came up in regards to the proposed right of inheritance in England of the Scottish post-nati in regard to the Religion Act of 1705. Now, what does Calvin case talk about? Let's read that. This is nothing new. We already talked about this. Well, Archbishop.
Calvin's case, also known as the case of the post-Nathi, was a 1608 English legal decision establishing that a child born in Scotland after the Union of Crowns under King James VI in 1603 was considered under the common law to be an English subject and entitled to the benefits of English law.
Read that again.
It says, Calvin case, also known as the case of post-Nathi, was a 1608 English legal decision establishing that a child born in Scotland after the Union of the Crowns under King James VI in 1603 was considered under the common law to be an English subject and entitled to the benefits of English law.
Now look at this, y'all.
Mhm.
It said you are a subject, entitled to be an English subject. So I mean, one, you're a subject of the English.
Mhm.
First point, you were subject to the common law. Second point, and the court who ruled on this is what? The Exchequer Chamber.
Anchor chamber.
If y'all don't know what the Exchequer Chamber is, you better ask Tyler Cherie, because he told you anybody standing below the Exchequer Chamber is in hell.
Hell. Yep.
All right. So if you are of Scottish descent, you were an English subject, and you got protection under English rights and laws, as it said under 61 under the what you call the escape clause, provided by if these colonies came back under the protection of Great Britain, then these charters that you're going by now are dissolved and inviolable. Why? Because under Calvin's case, it determined the birthright citizen, which said what? Archbishop, read on.
Calvin's case was eventually, you talk about the,
Read Calvin's case after the benefits of English law.
all right, Calvin's case was eventually adopted by courts in the United States. And the case.
Now, hold on. If they were adopted by the courts of the United States, and this case goes back to Exchequer Chamber, that means that the United States is practicing the laws of the courts of the Exchequer Chamber based off the subjects who are subject to the subjectivity of the crown of the kings of monarchs.
Yep.
I better listen to what's being said and what it say about those who are subject to the Scottish subjectivity under the English subjects. What does it say?
It says that they were English, that they had the rights of the Englishmen technically.
English, yep.
And then, like I said, that they're English subjects.
And it says the case paid what?
Oh, the Calvin's case was eventually adopted by the United States. The case played an important role in shaping the American rule of birthright citizenship via jus soli, which is law of the soil, or citizenship by virtue of birth within the territory of a sovereign state.
Okay, I better look at what it just said. It determined the law of the soil, i.e. jus soli, or territory. A territory is not the soil.
Mm-hmm.
The territory is just pointing out the jurisdiction where soil is at. You know what I'm saying? So one is a noun and one is a descriptive term. You know what I'm saying? So one says the law of the soil or jus soli, by virtue of the birth, which is the territory of the sovereign state. The state can be sovereign. We already proved that by its constitution.
Mm-hmm.
All right. Why? Because of understanding of the common law. It said it was considered under the common law to be English subject and entitled to the benefit of English law, but only under the Exchequer Chamber.
Yep.
All right. So let's get a history on common law, because we know under Article 3, Section 2, Clause 1 of the United States Federal Union that it said judiciary. It says judiciary powers should extend in all cases in law and what? Equity.
Equity.
And we got to understand what law and equity is and what the origin where law and equity comes from. So let's get a little quick feel about that. And our point reference. If I'm not mistaken, I think it's point. Y'all can see that?
Hasn't showed up yet.
Sure.
It not showed up. What was I talking about?
Not yet.
Yep, it showed up.
Point 10.
Point 10, Article 3, Section 2, Clause 1. The judicial power shall extend to all cases of law and equity. arising under this Constitution, the laws of the United States and treaties made or which shall be made under their authority to all cases affecting ambassadors, other public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between the state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between the state or the citizens thereof and foreign states, citizens or
Now,
subjects.
yeah, for citizens and subject. Now, all it says claiming the land. So this is automatically a chancery matter or equitable matter. But most of the things that are dealing with just sole citizenship and that deals with what you can inherit is under the common law, as you just said.
Yep.
And we know common law is different than equity law, but they both derive from England. And we know the law of common law is this. Read what it says, CA.
History of common law. Common law rules and ordination originate and were devised by the monarch's judge in England. During the early Middle Ages, these rules were mainly customary laws and judicial decisions of cases that were adjudicated in a common law court for ages. The English common law was developed mostly by judges of these common courts, then by legislator.
Did y'all hear that? Did y'all hear that? This is the difference between jurisdiction. Jurisdiction means declared law. Our declared law is legislative statutory law. Their declared law is their case law.
Mm-hmm.
That's the difference. Keep reading.
The common law had three central courts: Exchequer, Common Pleas, and the King's Bench. They applied the same laws, even though they were competed amongst themselves, who offered better remedies and increased their fees.
Okay. So what is that saying to them, CA?
Basically, that whenever you have grievance and stuff, you have different jurisdictional courts, Exchequer, Common Pleas, and the King's Bench, and the Exchequer being a court of belief, the Common Plea or Court of Pleas, as well as the Court of Common Pleas. So that was all considered hell. But the only sense of real birthright recognition would be with the King's Bench or the King's Consciousness. So even though they're all handled in the same facility, it's different outcomes and remedies per your jurisdictional or your equitable interests.
I love how y'all be sounding, boy. Music to my ears. All right, so we understand, as CA said, that the difference is the remedy that you get. You pay for what you get.
Yeah.
You know what I'm saying? You want to go pro se or hire attorney. Either way, you still getting got. All right? And you're not getting the equitable fairness in lieu of justice. Why? Because there is no fairness in it. Because you ain't got enough money. All right? All right, now let's see where the history of equity comes from. CA?
The history of equity was birthed due to structures and technicalities of the common law system. Disappointed litigants appealed to the king for justice to be served to them, justice outside of the common law courts. So, as the appeals intensified due to high number of people who didn't think the common law courts were fair to them, the king appointed his chancellor, who was his most trusted personal advice to petition the adjudication on them in the courts of chancery. He was called the keeper of the king's consciousness. An interesting part of this court established by the king through the chancellor was that he didn't follow precedents, unlike what was obtainable in the common law courts, just made justice somewhat harder, and he used discretion to administer justice as he intended to the particularities of each case. People preferred bringing their petitions to the Chancery Court than the common law courts, they became somewhat like rivals as soon began to conflict with themselves. The decision of the Court of Chancery was always different from the judgment of the common law courts, and usually people, after receiving judgment under the common law, they went ahead to Court of Chancery to find favor in the eyes of the chancellor.
Well said. So as we can see, in the eyes of law, there's only two: common law of England and the common law, in the Chancery. And as I said, two are they're not the same. They're in conflict with each other. And we know that, as we said, in lieu of the act has said that the Scottish subject will be subject to the English law, as English subjects under the courts of exchequer. It didn't say as the King's Bench or Chancery, because we know that's not the same. And we know, as Todd said, that courts of exchequer chamber are courts that deals with the debts that owes to the king. The courts of common pleas just with the civil and criminal affairs without the king's being there. And the king's consciences were actually, all three courts were actually uniform and one and the same until the Judiciary Act of 1873, when they split. All right, write that down, Judiciary Act of 1873. All right, so as we speak about the common law of England and the courts of equity, which the courts of the states have now, known as one, civil or special civil or criminal, and two, chancery, i.e. general equity, family part, and probate. So family part, probate, and general equity. And general equity is actually called God's law. Mm-hmm. It's considered God's law, or theology. That's what it's called. Theonomy. That's what it's called. The general equity is called theonomy, the law of God. Dios nomos. Right.
Theonomy.
All right. So all those who follow the common law, here's case law support what we just said. As we read a second ago, there is no common law in the United States in the sense of a national customary law, distinct from the common law of England. As it's common law in England, they get subject to exchequer chamber, exchequer pleas, and the King's Bench. And if you rock with the King's Bench, you have nothing to worry about, because the only thing that's going to be considered in your case is what's fair, what's equitable, and that's only heard in chancery in lieu of general equity, which is God's law, known as Theos Nomos. All right. So let's get into a little case law to support our argument. Let's first of all, let's deal with read this part in regards to establishing that English Parliament was established as our government in 1215. It extended before that, but we're just basing off that because this is the time when we were subject to inconveniences of barons who enrolled. This brought you into what we call the War of the Barons, the English Civil War, and the Glorious Revolution. All right. Now, when we get into the authority governed by charters, because we know charters does not establish the government, it's just a transmission of rights and powers. We must understand what a government is in regards to the government that were functioning at the time of the colonies in lieu of the charters given to those settlements known as plantations. Read what point 12 say, Archbishop.
Point 12. William Blackstone propounded his classification of English colonial governments. With respect to their internal polity, said he, our colonies are properly of three sorts. 1, provincial establishment governments. The constitutions of the first class, he said, rested on commissions issued by the crown to the governors and the instructions which accompanied them. 2, proprietary governments. The proprietary grants were of the nature of feudal principalities. 3, charter governments. The charter governments were civil corporations. The first point of criticism is that a little thought should make it evident that the word charter can never properly be used to describe a form of government. Charter is a document used for the transmission of rights and powers. In England, it has been used by the crown for the conveyance of powers in great number and variety. The grantees have been both laymen and ecclesiastics. Landed territorial privileges, rights of trade, and subordinate rights of government have been bestowed by the use of this document. Some of the grants have carried with them corporate privileges, many more have not. when the Crown employed agencies in the work of colonization, powers and rights were conveyed to them by charter.
Okay, that brings you to the United States Constitution, July 1776, in regards to the charter, which are power and rights by way of the transmission of the document via the Constitution, in regards to the corporate powers granted to the corporation, i.e. agencies. All right, because we know the state, per patriarch, is represented by the Attorney General, who's supposed to be looking out for the citizen as per patriarch when the agencies act up. But that don't work. That's not the case. The actual Attorney General is representing these so-called agencies when a citizen bring in the complaint. So that's a problem with that. You know what I'm saying? That's a breach of fiduciary duty. All right. And that brings us to the Supreme Court case of the Charitable Act of 1601, Elizabeth I, by way of a trustee charitable corporation known as the Trustees of Philadelphia Baptist Association versus Hearts Executor. Now, the Hearts Executor were trustees who worked in the association corporation known as Philadelphia Baptist, based off the beneficiary, based off the grantor, who had what we call a military certificate. Let's read the basis of the complaint, real brief. Go ahead and read, Archbishop. Now, it's in 1790.
All right, in the year 1790.
Stop right there. Remember, 1790 was the year of the Naturalization Act and the Funding Act and the Census Act of the United States of American Citizens, which preceded the Citizen Act of the Naturalization Act and Plantation Act of 1740 that resulted from the Act of Settlement of 1701, which was a result of the Foreign Alien Act passed by our ancestors, which was Parliament in 1705, to counter that.
Follow.
All right. So this is just showing the distinction based off Supreme Court case law in regards to charitable uses that was established on Elizabeth I, which was not based off heirs, intel estate, was based off trustees in lieu of associations, corporations, partnerships acting as trustees that would transfer those religious rights into corporations in place thereof. You follow?
Follow.
Okay, so this is the case law, Pennsylvania versus Pennsylvania Baptist Association, which is the association or branch or cadet branch of the Protestant Church. Yes, Baptist is a part of the Protestant Church. All right, so let's see what this case says in lieu of the 1790 Act of Celia Harris, who is a citizen of Virginia in 1790. That's no longer going by colonies, by going by states. Let's read.
All right. So in the year
Bishop.
So in the year 1790, a citizen of Virginia made his last will containing the following bequest. Item, what shall remain of my military certificates at the time of my decease, both principal and interest, I give and bequeath to the Baptist Association, that for ordinary meets at Philadelphia annually, which I allow to be a perpetual fund for the education of youths of the Baptist denomination who shall appear promising for the ministry, always giving a preference to the descendants of my father's family.
Stop. So now, the grant was given for military certificate, but it was based off a testator's will. Because it said based off the descendants of my father's family. Right? So it's supposed to stay within the family, but it didn't fall under the family because it was being presented to the court by trustees. All right, as we're going to read it as we further go down. Go ahead and
remain business practice.
Yeah, business practices. Go ahead.
In 1792, the legislature of Virginia passed an act repealing all English statutes.
Stop. What?
What?
You repealed all the English statutes? Why would you do that? So you can get what you're doing off.
Under what authority?
Yeah, under what authority are you have the right to appeal English statute when according to the original Constitution, where you got your state legislation from, your Constitution. Let's roll. Let's read. Go ahead and read, brother.
In 1795, the testator died. The Baptist Association in question had existed as a regularly organized body for many years before the date of his will, and in 1797 was incorporated by the legislature of Pennsylvania by the name of the Trustees of the Philadelphia Baptist Association.
Stop. Now remember Dartmouth versus Woodward. Dartmouth College versus Woodward. The New Jersey State Legislature tried to revoke the charter for the Royal Charter of Dartmouth College, which was a Royal College, it was a Royal a colonial college given by a royal grant, then replaced by the state legislator by a legislative charter, which is not a government.
Mm-hmm.
All right, go ahead.
Held that the association, not being incorporated at the testator's decease, could not take this trust as a society, that the bequest could not be taken by the individuals who composed the association at the death of the testator, that there were no persons to whom his legacy, were it not a charity, could be decreed, and that it could not be sustained in this court as a charity. Charitable bequests where no legal interest is vested and which are too vague to be claimed by those for whom the beneficial interest was intended, cannot be established by a court of equity, either exercising its ordinary jurisdiction or enforcing the prerogative of the king as parens patriae, independent of the statute of Elizabeth I.
Stop. Okay, so what it's saying is that as a result of it not being the beneficiary to support the legacy of a deceased who left it as a grantor but didn't have a will. A testator is somebody who died without making a will. All right, so the trustees who were then incorporated by the state legislator, they made a claim on behalf of the estate, and the court of equity could now rule in favor of it, because in order for the case to be heard, it has to be presented by parens patriae as the attorney general, and not the king, because the king has descendants, it has heirs. Follow?
Follow.
And we know the descendants of those monarchs is not based off heirship. Why? Because we know that laws forbidden it, such as the Elling Act of 1705. All right, keep reading.
It says, if in England the prerogative of the king as parens patriae would, independent of the statute of Elizabeth, extend to charitable bequests of this description, quaere, how far this principle would govern in the courts of the United States. The English statute Elizabeth gives validity to some devices, to charitable uses which were not valid independent of that statute, held that it was unnecessary to enter into this inquiry because it could only arise where the Attorney General is made a party.
Okay, so as we said, as we continue to say, the Attorney General is the representative for the nation, i.e. United States. He's called the father of the country.
Mm-hmm.
Because he's the representative for any state, agency, etc. All right. So as subjects of the king, he could not represent us.
Yeah,
we need the king, parens patriae, as father of the country, that he is the king. In order for that to happen, you must have a king. You must have heirs. You must have successors. You must have a lawful claim. And the only way to present that claim is not in the court of law, but a court of equity.
Yep.
All right.
Chancery.
Now let's go on. Chancery, exactly. Because chancery and equity are one and the same. Now let's read about the actual citizen, Silas Hart.
All right. In the year 1790, Silas Hart, a citizen and resident of Virginia, made his last will in writing, which contains the following bequests. Item, what shall remain of military certificates at the time of my decease, both principal and interest, I give and bequeath to the Baptist Association for ordinary meets at Philadelphia annually, which I allow to be a perpetual fund for the education of youths of the Baptist denomination, who shall appear promising for the ministry, always giving preference to the descendants of my father's family. All right, we read that.
Okay, yeah. So as we can see in this case, that the court of equity or chancery will not sustain a claim in a court of chancery if there is no living beneficiary in lieu of a trust or will that was presented without a testator. So there's no way to prove it other than you a parens patriae, i.e. Father of the country. Because that's the only way you can be a descendant is by being the heir of a monarch or a king.
Mm-hmm.
Because you couldn't transfer property under common recovery under subrepudiation if you weren't an heir. Because that would cause subrepudiation. That's been overruled and disqualified by case law under common recovery. All right. Now I'm gonna bring you to another case with the same subject matter in regards to a charitable association that makes reference to the case we just made in regards to England versus Nicole Harbor, which was another charitable set up by as a military quorum for soldiers. Right? We'll be coming to our closing. English versus Trustees of Sellers Snug Harbor. All right, here goes the syllabus. Read the syllabus, Archbishop.
All right, it says, the testator gave all the rest and the residual and remainder of his estate, real and personal, comprehending a large real estate in the city of New York, to the Chancellor of the State of New York and the Recorder of the City of New York, to have and to hold the same unto them and their respective successors in office, to the uses and trust, subject to the conditions and appointments declared in the will, which were out of the rents, issues, and profits thereof, to erect and build upon the land upon which he resided, which was given by the will, an asylum or marine hospital to be called the Sailors' Snug Harbor, for the purpose of maintaining and supporting aged, decrepit, and worn out sailors. And after giving directions as to the management of the fund by his trustees, and declaring that the institution created by his will should be perpetual, and that those officers and their successors shall forever continue the governors thereof, he adds, it is my will and desire that if it cannot legally be done according to my above intention by them, without an act of the legislator, it is my will and desire that they will, as soon as possible, apply for an act of the legislator to incorporate them for the purpose above specified, and I do further declare it to be my will and intention that the said rest, residual, etc., of my estate shall be at all events applied for the uses and purposes above set forth, and that it is my desire all courts of law and equity will so construe this, my said last will, as to have the said estate appropriated for above uses, and that the same shall in no case, for want of legal form of otherwise, be so construed as that my relations or any other person should e'er possess or enjoy my property, except in the manner and for the uses herein above specified. Within
Okay.
5 years.
Let's go stop right there.
Okay.
So in this case, he said if it could not be done lawfully, he would ask the legislator to incorporate. Why would you do that?
That's
So he said if you were not able, he said building on the land, showed you that he had no intel estate here. Because he said to build on the land, he wanted to set up a trust, i.e. a will, in lieu of courts of law and equity, that it can be sustained either in the court of law or equity, if not done based off the legislator, but then in way of incorporation. Ours was done by way of the will and the trust supported by incorporation. That's the difference. All right. Now they make reference to it by supporting case Pennsylvania Baptist Association. Now look what the case is based on. Now they make a reference in England versus Snug Harbor, and they're using the Baptist Searching case to support it. Read what it says.
It says, in the case of the Baptist Association versus Hearts Executors, the court considered the bequest void for uncertainty as to the devisees, the property vested in the next of kin, or was disposed of by some other provisions of the will. If the testator in that case had bequeathed the property to the Baptist Association on its becoming thereafter and within a reasonable time incorporated, could there be a doubt but that the subsequent incorporation would have conferred on the association the capacity of taking and managing the fund? Whenever a person by will gives property and points out the object, the property, and the way in which it shall go, a trust is created, unless he shows clearly that his desire expressed is to be controlled by the trustee and that he shall have an option to defeat it. What are the rights of the individuals composing society and living under the protection of the government when a revolution occurs? A dismemberment takes place, and when new governments are formed and new relations between the government and the people are established. A person born in New York before July 1776 and remained an infant with his father in the city of New York during the period by the British troops. His father was loyalist and having adhered to the British government and left New York with the British troops, taking his son with him, who never returned to the United States, but afterwards became a bishop of the Episcopal Church in Nova Scotia. Such a person was born a British subject and continued an alien, and is disabled from taking land by inheritance in the state of New York. If such a person had been born after July 4, 1776 and before September 15, 1776, when the British troops took possession of the city of New York and the adjacent places, His infancy incapacitated him from making an election for himself, and his election and character followed that of his father, subject to the right of disaffirmance in a reasonable time after determination of his minority, which never having been done, he remained a British subject and disabled from inheriting land in the state of New York. The rule as to the point of time at which the American ante nati ceased to be British subjects differs in this country and in England, as established by the courts of justice in the respective countries. The English rule is to take the date of the Treaty of Peace in 1783. Our rule is to take the date of Declaration of Independence.
There you go. July 2nd, 1776. So, date 1 second to make sure I covered everything. Yeah, so as you can see, oh, I got one more to show you. So this is the Constitution of July of Virginia. Now, on June 29, 1776, Virginia established their constitution. And one of the clauses says this. Read this right here, Archbishop.
All right, just got to share it up from screen. All right.
Let me go ahead. Hold on. Well, this is all the points they make up for drafting this Constitution. And this is one point they made in lieu of the Constitution, in lieu of all the other sections that are attached to it. This is what they say. Read what it said.
It says, by prompting our Negroes to rise in arms amongst us, those very Negroes whom he hath from time to time, by an inhuman use of his negative, he hath refused permission to exclude by law.
So back to what King George officer said in the movie Patriot, that if you fight on behalf of King George, you'll win your freedom. But as the people said, we're not slaves. We were free men. And the only way we can consider free men is to understand the origin of who we are as English people and protected by the laws of English people, i.e. those legislative acts, which precede the legislative acts of the states, because states never existed prior to the contracting parties, who were the English, on behalf of the heirs and successors that were being yielded by the settlers from settled plantations, who were those Protestant communities who broke away from the Roman Catholic Church and took our place as Protestants as a reform of the English Church, now known as the English Third Temple Church of England, which we come to restore. And with that, I'm gonna say peace. Hope all the information that I give to you were clear. I'm pretty sure no one can do better than that. I leave all closing remarks to Archbishop and CA. I love you all. And I'm pretty sure after the review of these classes, there's nothing disputable that can be submitted in lieu of these claims that are brought by the English Third Temple Church on behalf of our vast state, which is protected by legislative authority of our legislative ancestors, known as Lords and Peers. And with that, I'll say peace and love. Archbishop.
There you have it. The people from the Kingdom of England and Great Britain, aka Albion, we are still subjects of the King, as well as heirs and successors of those who have pledged their allegiance and fealty to the monarchs of the Kingdom of England, going back to time immemorial. And as you've seen, even those who have came and so-called usurped our home, they still had heirs themselves who were trying to maintain our customary rights and laws and traditions, even though they were not the true inheritors of it. And so all thing we need to do is realize that what our ancestors have set up and have worked through them to do, maintain our identity. And now that we need to come back into the proper state of the living. And the way for you to come to the proper state of the living, you must be conscious. And the way for you to get your conscience where the holders of the King's conscience can bring you back the water, aka the memory that you need. So that way you can realize that not only are you an English heir, English subject, but you still have your rights and birthrights. You still have your rights protected for you, just based off of you coming back home and being a true understanding of who you are. You already know everyone is not going to do this. As you see, many of our brothers and sisters are aiders, abettors, and comforters of foreign authority, which we are seeing based off of the Religion Act of 1580, told you was high treason. Now that they see that they're in the position of high treason, they're still committing it based off of keeping up with the status quo of the so-called states, which we know are actually rebels or rebellion. You know, they're not doing what they're supposed to be doing. They're going to bring you down with them. They already told you ignorance of the law is no excuse, because they know they have to know the law. They know this. But for them to continue to keep their rule over you, which is this Roman rule, is they need you to make sure that you don't remember who you are. And like I said, we are back now because we're bringing you the king's conscience, which is natural law. And so failure to heed the warning, like I said, your fate has been sealed. So I leave the rest of the closing to C.A. Murphy from the Noble House of Murphy. And once again, only way for you to become counted amongst the living, you have to come home. You have to show your fealty and your allegiance back to the English church, as well to the Kingdom of England, Empire of Albion. And if you don't show your respect by coming and doing your due diligence by coming to services, then you will not be on the Master Rolls book when I have to write the names down to everyone who was actually members and being accounted for, as we give those who are Caesars back to Caesars and render to God, which are those underneath the Third Temple English Church of England. So with that being said, I love you. We want you to do the right thing, you know, but every man and woman must carry their own cross and worship under their own vine and fig tree. And the only one that has the supreme law and birthright here are the English heirs. So with that being said, I leave the rest to C.A. Murphy.
Well said, Archbishop.
Bishop, gratitude and honor to the King's Bench for a marvelous lesson. I trust all is well to receive. All those at the sound of my voice who commune with us. We've done a qualified timeline of the history lesson session from your last pharaonic dynasty, Samsuk, on into the Iberian Peninsula Kingdom, Kingdom of Libya, into the English Anglo-Saxon Berber territory known as England, be it usurped through the British business tactic, through the House of Tudors, on into your present day exchequer plead controlled states. You have rights entailed, but you must honor them. For any rights that you do not claim, you do not have. So your birthright is intact and available to and for you, and it is only in your perfection of those statutes and laws and legislators and parliament acts that precede you that you can ensure your salvation for yourself and your posterity. We like I said, we do this out of the fealty of our allegiance to the positive good works and good. There's no payment for this, you know. The only payment is your attention. The lessons are free, but you have to pay attention. So in honoring your foremothers and forefathers, we know that you will come into a place of reconciling your history, not a because it's not a mystery school. This is the King's Bench, and you can find further clarity in Clifford's Inn. But the natural law, that which is part of your monarchy, your de jure monarchy, and your salvation can be found under the King's consciousness, which we've proven will provide more clarity and harmony for your plight. I love you all at the sound of my voice. I trust in all you're getting. You'll get concrete overstanding opposed to that of abstract understanding. And I yield the floor with the best of wishes to you all. We greet you in modern principles of love, truth, peace, freedom, justice, and equity or equality.
Well said, well said. Both bishops of the King's Bench. And as I stated earlier, I get gratitude for such stewardship in lieu of the fealty, because like I said, we truly are concerned about our present estate. As you can see, as I was trying to show you, brothers and sisters, earlier, that we are taking our place in the affairs of men, and it's not in the streets, it's in the courtroom, and it's not in the courts of law, it's courts of chancery, i.e. general equity. As you can see, they can see the screen?
Yep, we can see it.
Okay, just blow it up a little bit so y'all can see. For all you leaders, students, and who follow leaders, this is what should be done on their behalf as a protector of the people. As you can see, Superior Court, New Jersey, Blister County, Chancery Division, General Equity Part. No docket number yet, but this is the order so-called, i.e. called warranto. Called warranto origins comes from English law. As you can see, plaintiffs, Third Temple English Church, successors, heirs and successors, a corporation sold. As you can see, the defendants are the states of New Jersey, New Hampshire, Massachusetts, Rhode Island, Connecticut, New York, Pennsylvania, Delaware, South and Maryland, Virginia, North Carolina, South Carolina, and Georgia, ETAL. Called warranto, English heirs, successors, brief and appendix, Third Temple English Church, King, successors of England, corporation sold, i.e. King, Council of Lords, Archbishop Jerome Murphy, Archbishop Belmont. There's our website, our Gmail account, the date, our ID number of our incorporation, and IEN number. This is the table of contents. As you can see, issue concerning matters in lieu of slave trading, trafficking of English heir successors, grounds for relief, free and common succors, our conclusion, supported statutes, case law. Just go a little bit. Statutes, Virginia codes that we mentioned earlier, Dormant's cards we mentioned earlier, Dred Scott versus Peck, Holmes versus Walton, Holy Trinity versus United States, Evangelical Lutheran Church, Marbury versus Madison, Municipal, Ponce, Trade versus the Whedon, that's dealing with negotiable instruments, citations, exhibits, etc. We got it all. We let you know that we really take our place. We really deal with the matters at hand in regards to getting equitable and just relief from those who are able to give that, who are aware of the King's conscience, which I, your King, had brought forth to the people. So with that, the King's bench is tuning out. We meet y'all in the next episode coming soon. Peace and love.
Peace and love, family.